Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Rachel Schwartz and Ryan Bates. Two six oh.
Good morning, Judge.
Good morning. Mr. Bates, good morning.
Morning, Your Honor.
This is file number 21-164-260. The file is entitled Ask Cares Pharmacy versus State Farm. Could I have your appearances, please?
Rachel Schwartz on behalf of ASP Cares P54947.
Ryan Bates for defendant State Farm P77460.
Where are we on this file?
Well,
We're within spitting distance of resolving this, Your Honor. I'm waiting on a call back from my client on Ms. Schwartz's most recent demand.
Okay. Then why don't I just give you all a date and get you out of here?
That works for me if it works for Ms. Schwartz.
of course, sure.
Because otherwise, I'm scheduling motions about excluding information about a trial that apparently is not going to happen.
Yeah, no, I mean, I think we're like $800 or $1,000 apart. So I think.
Now, if we were in my courtroom, I'd bring you up to the bench and I'd bang your heads together.
Well, to be honest, Your Honor, though, that just was 5 minutes. We just talked 5 minutes ago. So I think we'll get it done eventually, but I know.
Let's get you a date and get you out of here. Let's have you back on Friday, October 21 at 10 o'clock. Does that work for everybody?
Let me just make sure. Shoot, I'm not. Yeah, it'll be fine.
Mr. Bates?
Yeah, that'll work for me as well, Judge.
Okay, October 21st at 10 o'clock will be our next pretrial, and let's not have it
Yeah, we.
that close. We need to kill the file.
We agree.
Okay, thank you.
Okay, thanks for coming in. Let's be safe.
Okay.
Yeah, you as
too.
well. Have a
Bye,
good weekend,
Judge. Have a
everyone.
good day.
Bye-bye. Hello? Hello?
Hello, good morning, Your Honor.
Good morning. What is your name, ma'am?
My name is Maureen Punsalan.
Okay, I have Beaumont Hospital. We should be able to get started in just a second.
Okay.
Mr. Conway?
Good morning, Your Honor, or afternoon, Your Honor.
No, it's still morning.
Okay,
That's where I am. We are on the record calling file number 221918999, Beaumont Health versus Maureen Ponsalon. Date and time for pretrial. Could I have your appearances, please?
my name is Michael Conway. I'm appearing on behalf of Beaumont Hospital.
Bar number.
P12165.
And tell us your name, ma'am.
My name is Maureen Punsalan.
Ma'am, is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you would like to represent yourself, as is your constitutional right, the same rules that bind Mr. Conway will bind you. Do you understand that?
Yes.
All right, this is our first pretrial.
Your Honor,
Yes,
Your
sir.
Honor, might I interrupt the court? We have arrived at a settlement of this case.
You have arrived at a settlement. Please tell me the terms of the settlement.
The settlement is that there's outstanding, excuse me, the judgment was $1,384.70. The defendant is making $150 a month payment towards that indebtedness. And what we have are hoping to do is get a consent judgment embodying the $150 payment per month, and that's in essence the resolution of the case.
Ma'am, did you understand what counsel said?
Yeah. I have an agreement for them.
You agree
Paying
with those
100.
terms?
Yeah, 150 every 2 weeks of the month.
Have you sent the proposed consent judgment to her counsel?
Your Honor, that's what we want. The time is give us 2 weeks and we'll get a consent judgment in.
All right, then
And-
what I'll do is I'll just give you a date, and you can get the consent judgment in. Your next date will be October 21st at 10 o'clock. Now, I don't expect to have to see you on that date. I expect by that time you'll send in the consent judgment. So ma'am, when he sends it on out to you, you need to sign it and get it in so that we can get it entered and you don't have to come back. In the meantime, I'll calendar this for October 21st at 10 o'clock. Thank you both for coming in.
Thank you, Your Honor. Good to see you.
See you.
Your Honor, do I need to come? Do I need to come again on
Ma'am,
October
if the
21?
consent judgment has been signed, you don't need to come. So what you do, as soon as you get it from him, review it and sign it, send it back to him. He'll enter it with the court. The court will send you a copy of that once it has been entered. We will not need to come if the consent judgment has been entered by that time.
Okay.
Okay?
Okay. Thank you, Your Honor.
Yes, ma'am. Let's be safe out there. Thanks for coming in.
Thanks,
Okay,
Judge.
thank you.
Bye-bye.
Okay, bye-bye.
Good morning.
Good morning, Judge.
We are on the
morning.
record. We are calling file number 22243029. The file is entitled Deborah Love versus Princeton Management River Place. This case comes to us by way of a removal from the small claims docket. Could I have your respective appearances?
Christopher Asphalt, 53129 for the defendant.
And what is your name, ma'am?
I'm Deborah Love. I'm the plaintiff.
All right. I wanted, before we get started, I want to explain something, make it very clear that, how to say this. The landscape has changed beneath your feet, Ms. Love. You started an action in small claims. In
Yes.
small claims, lawyers are not permitted. The court is not required to follow the rules of evidence other than privilege. The court is not even required to follow the case in statutory law, but is to do, quote, substantial justice. The defendant removed the matter to the general civil docket and filed an answer. The general civil docket, where we are now, is very different. It is much more formal and structured. In the general civil docket, the rules of evidence do apply. The court is required to follow the case law, statutory law, and court rules. So we're not in the informal mode that you were in small claims. I say that to you because I want you to consider getting counsel to represent you. Now, you need to understand that you have an absolute constitutional right to represent yourself, even though we're no longer in small claims. However, what you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind the lawyer for the defendant will bind you. Do you understand that?
I do. Yes.
So where are we on this file, people?
I have not been able to speak with the plaintiff. That's the first thing I wanted to say. Certainly, I am willing to do so. But Judge, I just wanted to confirm, I don't know if I have the full answer. I have a copy of the affidavit and claim that she filed, and it's very hard for me to read. That's one thing. I don't know if she can send me a better copy, but it appears that it says see attached on paragraph 7. Is there an attachment that the court has that she filed that I do not have?
I have the complaint that was filed in the small claims division. And there appears to be one, two, it seems to be several pages of typewritten information that were appended to that.
I do not appear to have that. So maybe Ms. Love can, I don't know if you have a scanner and email, or if you could email everything you filed with the court, or if you prefer, you can mail it to me.
I can email you everything that I submitted to the court. Yes.
Okay.
All right. Then you-
Maybe we can meet in a breakout room after the hearing today and I can get all my information.
Okay.
And the second thing I wanted to bring up, Your Honor, is I'm requesting an order to allow us to amend our answer to add a counterclaim for breach of contract.
Well, what I would suggest in that regard is twofold. Number one, as you know, the first requirement is that you attempt to obtain that by stipulation from the other side before you're in position to file a motion. If you're not there, then you have to file a written motion, given the fact that you just filed an answer. You certainly had a right at that time to file a counterclaim, but elected not to do so.
Very good, Judge.
So let's get you a date to get you on your way. Does October 21st at 10 o'clock work for both of you for our next pretrial?
Yes.
Yes.
That work for you?
That works for me, Judge.
All right, here's what we're going to do. I'm going to open your written discovery at this time. And I'm going to put you guys into a chat room so you can have your conversation. I will talk to you again, October 21st at 10 o'clock. Ms. Love is going to scan and send over to counsel for the defendant the attachments that were provided at the time of her complaint. Counsel, you're going to talk to her about getting her stipulation for a filing of a counter complaint. If that is not something parties agree upon, you have to file your motion. You may calendar your motion for that October 21st, 10 o'clock time frame.
Very good.
Okay, now we'll put you guys into a chat room and hopefully you can resolve the matter. If not, October 21st at 10 o'clock, we'll try it again. All right,
Thank you so much, Your Honor.
put you in the breakout room. Assume I can make the technology work, right?
Mhm.
There is always that. Okay, he's gone. She's gone.
Good morning, Your Honor.
Good morning, Mr. Barter.
How are you, sir?
I'm good. How are you?
I'm doing well, thank you.
What brings you here today?
I believe I have, bear with me for one moment, I have a motion to reinstate after dismissal for credit acceptance versus Shanita Holden and Tiana Holden.
Okay, I don't have anybody as of yet. So I'll put you back in the waiting room and we'll see where we're going.
Thank you.
Let's see.
Woo, in the name of Jesus and the Holy Spirit. Yeah, I'm not, he's like, can you pay $1,000? I'll pay y'all $1,000. So this won't go on my credit and all this and that, because I breach my lease, or I'll just get me an attorney. You know, it's whatever. The judge said, Ms. Love, I advise you to get representation. I'm telling you that you can represent yourself, but I'm advising you to get representation. He said, this baby was trying to get a counterclaim, and the judge was like, no, you had the opportunity to do that when you filed your answer, and you didn't do that. So you would have to bring it to court again on your own. And so the judge said, maybe y'all can just figure some things out. Maybe y'all can figure some things out in the breakout room. And I said, I have all my footage. He said, I understand. He said, but we have not been able to re-rent that place. So you put us in a bad situation. What about my health? I said, what about my health? What about my headaches? What about me being back on blood pressure pills? What about me, being able to thankfully be here talking to you now? If they hook back up the faulty line. I said, I have.
We are on the record calling file number 22187-868. The file is entitled Benjamin Bernuti versus Vincent Cooper. We were last together on this file on August 26, 2022. At that time, the parties in court agreed to today's pretrial to be set for September 23rd, 2022 at 10 o'clock. It's now after 10:30, neither party having appeared, the matter dismissed without prejudice. We are off the record. Mr. Barter, I'm having your file brought up from the second floor. It
Perfect.
appears that an error was made. Your office filed a motion to reinstate a case that had not been dismissed. What had happened apparently is we had sent out a notice of intent to dismiss. And in response to that, their court entered in mid-September a default judgment as to one of the two defendants and a default as to the other. But I should have that file for you in the next couple of minutes, and I'll go over with you on the record.
Perfect. So just so you know, Your Honor, I'm looking at the dismissal on both defendants that we received from the 36th District Court. So I guess we'll figure when that
What's
final
the date of that?
comes. Pardon?
What's the date of that dismissal?
7/26/22.
7/26. That's interesting. I'll get back to you as soon as I get the file.
Okay, thank you.
Thank you. Hello? We are on the record. This is 22-140-054. Credit Acceptance Corporation versus Shanetta Holden, Tiana Holden. Your appearance.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of Credit Acceptance Corporation.
All right, Mr. Barta, we seem to have a failure to communicate here.
I believe so.
August 23rd, 2022, the court entered an order for reinstatement of the dismissed action. Do you have that?
Do not.
That's the problem. Yeah,
So it got reinstated without hearing?
no. It says plaintiff, I'm looking at the register of action. 8/23/22, motion, review was scheduled on that date for today. But on the 8/23 day, case called, plaintiff present via Zoom, defendants not present via Zoom, and then the copies mailed. Now I'm looking at the order.
Was it then set for a pretrial for today? Because that's 30 days from.
Now set for a review date. Because by that time, you were at a position where you wanted to have the defaults entered because you had submitted the proofs prior to the time of the matter being dismissed.
Wow.
Then it appears that on September 15th, your office filed a request for default as to defendant one, who would be Shanetta Holden. On September 21st, the court entered a default as to Shanetta Holden. And on September 21st, a default judgment in the amount of $15,924.60 as to defendant two, Tiana Holden.
So I take it a default for that other, so Tiana, there's a judgment entered against her.
That was on 9/21/22.
And then a default was entered against the other defendant, but not a judgment yet.
Right, the default was entered against Shanetta Holden on 9/21/22 as well.
Do I need to do anything to get that default entered for her? Or does that just the time thing?
I've entered the default. You
Yes.
have to, under the court rule, serve her with a copy of the default. And then you move forward seeking your default judgment.
And that was as to Shanetta.
As to Shanetta, judgment was entered on 9/21 as to Tiana Holden, defendant 2.
Perfect. I will do that right away.
Okay,
Sorry for the confusion.
that's all right. I'm paid to be here all day.
Have a wonderful day.
Enjoy your weekend.
All
Thank
right,
you
you
for coming
too.
in.
Bye.
You're off the record. And do it now.
The third in our set of signature works this hour is modern, almost romantic style.
Counsel,
Morning, Your Honor.
good morning. Good morning, ma'am. What is your name?
LaShante.
All right, we are on the record calling 22-189-949 Crown Asset Management versus LaShante Ambrose Turner. Matter before the court today, what appears to be our second pretrial, your appearance.
Good morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
And what is your name, ma'am?
LaShante. Ambrose Turner.
All right, where are we on this file, people?
Well, she had made an offer and I don't know if it was communicated to her or not since the last one. My client denied her, rejected her offer. So we can either try to.
Are you gonna do any written discovery, either of you? Court opened written discovery on August 26th. Are either of you planning on doing any written discovery?
No, Your Honor.
What about you, ma'am?
I don't have anything to offer. Like what I did when making an offer, I did ask for a breakdown of the bill, which was not in the discovery. And he said that he didn't have it available. So that's why I offered the 40% of the balance. Because I don't have it.
Let me stop you here. The court does not get involved in settlement negotiations, and you should not tell me anything about your settlement negotiations. Either that you settled or you don't. Don't tell me about anything about the substance.
Okay.
Written discovery is your opportunity to get information about their claims and the defenses. You can file such things as productions of documents, written interrogatories. Interrogatories are questions to be answered. Written questions to be answered. Request for production of documents to seek specific documents, and request for admissions. So what I'm going to do is I'm going to give you another opportunity to do written discovery. I'm going to give you a return date of October 21st at 11 o'clock. If neither of you have done any written discovery by that time, I'm going to close it. Does that October 21st date work for both of you?
Yes.
Yes, sir.
Okay, we'll see you October 21st at 11 o'clock. Your written discovery will remain open. Thank you both for coming in.
Thank you.
We're off the record. Good morning.
Good morning.
Good
We are
morning.
on the record. This is file 22-186-030. Progressive Marathon Insurance versus Reliable Heavy Freight and Darren Stinson. This is our second pretrial following a failure of the initial pretrial. Your respective appearances.
Good morning, Your Honor. Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
Good morning, Your Honor. Remo Dinverno appearing on behalf of the defendants.
You remember the State Bar of Michigan?
I am P number 81979.
Where are we, people?
But Your Honor, the parties are in process of resolving the matter. We are discussing and working on a release and negotiating the terms. And then I anticipate this matter being resolved and a dismissal filed as soon as that's completed.
All right, so you've agreed on the number and you're fighting about paperwork.
That is correct.
Well, the case is done. I'll give you a return date. I don't expect to see you. Return date will be October 21st at 11 o'clock. Let's get your paperwork in before then, so you don't have to come in and spend time on a case that apparently has already been settled.
Great, Your Honor. Thank you.
Thank you.
Let's be safe out there. Thanks for coming in. We're off the record.
Thank you.
Thank you.